Good morning, sir. Thank you for joining us today for this special session. We are very much excited to have you here, sir. Uh, it's my absolute pleasure to introduce our guest speaker, Dr. Bharat N. Suryavamshi, Assistant Controller of Patents and Design, New Delhi, Government Office. He has been into office since more than 20 years in this office and Patent Office, Ministry of Commerce and Industry, and presently Assistant Controller of Patents and Designs. And he has been a part of he has published various national international papers. He has delivered many lectures on IPR in various parts of country, and he was deputed for training in at Tokyo, Japan, on examination and the IPR issues. He has been a part of various judicial, national, international training programs regarding IPR practices. He has given a landmark decision by rejecting Pfizer patent application for arthritis drugs, which was filed in India. So it's really a great thing that we have you today here, sir. We are honored to have you here, and today, sir is there to give insightful lecture on the topic intellectual rights, patents, design, and filing. Sir, please join me in giving me a warm welcome. Sir, welcome, sir.
Thank you, ma'am.
So without further delay, I just want to hand over to sir to begin his presentation.
Thank you,
Sir,
ma'am. Thank you
please.
so much. Yeah. I also welcome you all for the IPR session on behalf of Rajiv Gandhi, Nationalist of Intellectual Property. So first, I'll deal with all the office where they are located. I'll give the brief introduction of my offices. We are comes under the Office of Control General of Patents, Designs, Trademark, and Geography Indications. We are having office at Kolkata, New Delhi, Mumbai, and Chennai. We are having training center only one in India, that is Nagpur. We are giving physical as well as online training programs. We are having trademark offices in addition to four. One is at Ahmedabad, Gujarat. Geography Indication Office at Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. This is our training center where I am sitting and delivering this lecture. This is our website. If you are not aware of IPR, please log on to this. Again, we are keeping on Facebook and Twitter also. Let us see today's topic. What is intellectual property? You can see my slides. I have shown something blooming or lightning in the mind. It means I want to make you understand that the product of mind is called intellectual property. Now, the question may arise, what may be the product? For example, today you are thinking to write new book. That's idea to write a new book is originating from your mind. That's again intellectual property.
Sir, slides are not visible, sir. Sorry for interrupting.
Not visible.
No, sir, we can't
Okay.
see the slides.
Earlier you have seen now.
No, sir, we couldn't.
Okay, again I'll share again. Okay.
Okay, sir. Okay.
स्क्रीन शेअर होत नाही. ये लवकर करा सिस.
So I think you have closed the window, sir. Yeah, now I got it. Yes.
So
Sir, can you please put it on slides full
yes,
screen, sir?
I'm doing that. Now it's okay.
Yeah. Yes, sir.
Are you able to
Thank
see? Are you able to see?
Yes, sir. Clear, sir.
Okay. See, I told you, you can see my slide. I shown something lightning or blooming in the mind. It means I want to make you understand that the product of mind is called intellectual property. Now, the question may arise in your mind, what may be the product? For example, somebody is writing a new book. The idea to write the book is originated from your mind, so it's an intellectual property. At present, we know there is no herbal medicine for the cancer. So somebody among you or anyone is thinking to give herbal composition for cancer. The idea to prepare a composition, to develop a composition is originated from your mind. Therefore, it's an intellectual property. If you're writing books, novel, story, or creating any technology, product or process, composition, that are idea to develop are originating from your mind. Therefore, simply we can say the product of mind is called intellectual property. For example, in December 2019, we heard about the coronavirus. At that time, we are not having any vaccines. So, scientists all over the world started to carry out the research. And in the middle of 2020, we got Covaxin, Covishield, and Sputnik. What is that again? The idea was donated from the mind of intellectuals to give the composition of vaccine. So again, it's an intellectual property. I'll quote another example to make you understand. At present, we know petrol and diesel, the rates are getting higher day by day, and somebody want to solve the problem by giving the biodiesel, or it may not available for the next generation because it's not a renewable source of energy. By keeping all the aspect or drawback in the mind, you are or anyone is trying to give process of production of biodiesel. So idea to develop that process is originated from your mind, therefore it's an intellectual property. So any idea, that may book, story, technology, process, product, composition, whatever you are arising from your mind, all comes under the intellectual property. Let us see how this property arises. When you are in the classroom with your students, discussing on a particular topic, or you are in the laboratory doing some research, or sitting alone or in a group of people and discussing on a particular topic, and during the discussion you are getting solution, or some ideas arises from your mind. So the product of human creation is called intellectual property. Is it clear? For example, one of the company has developed smart shoes. Why can't Bata, Puma, Adidas? Austrian company has developed. They have studied the problem of the blind people. They cannot walk easily. Sorry. Therefore, they have brought the ultrasonic sensor used to make the shoes for the blind people to detect the obstacles up to 4 meters away. There was a problem for the blind. Somebody is giving solution for that in the form of shoes. That's great invention for the blind people. I'll give another example to make you understand. One of the professors from Nagpur has developed cold drinks from moa flowers. The botanical name is Maduka longifolia. The These flowers were earlier known for only production of the liquor, but now he has produced cold drink out of that. Surprisingly, people like the taste of that moa drink. So it's again new technology. Somebody's brought new composition for the cold drinks. Tea climbing machine, washing machine, compositions, water walking shoes, vaccines are the examples of invention or technology. Let us see what is the background of intellectual property. Property means your mind directly goes to the tangible form of property and you say, I am having car, gold, plot, flat, so I am rich enough. But there is another kind of intellectual property which is intangible form of property, that is intellectual property or creations of your mind property. That is industrial property and copyright, wherein patents, trademark, designs, geographical indication, layout of circuit, protection of plant varieties, and trade secret are the different kind of IPR. Let us see one by one. What is intellectual property? I told you product of mind, but how to define that? Intangible creations of human intellect. You are the intelligent animal in the animal kingdom, having power of thinking. Therefore, we are developing many machines like CT scan machine, MRI machine, many formulations because we are thinking and creating. And it has a commercial value asset like any other form of property. As I told you, if you are able to give biodiesel, any company like Reliance, HP, or Bharat Petroleum can approach you for the licensing. You are giving the formula, you're getting money out of that. Therefore, it's asset like any other form of property. IP is called as an exclusive right. Somebody is filing patent from your college, the right is with them, not with their children's or spouse or parents. They cannot exercise. Therefore, IP is also called as an negative right. Again, IP is an territorial right. Once you are filing your patent application in India, it's valid only in the country of India. You cannot claim in USA, Japan, Germany. because you are not filing those country. If you want to file, there are two routes to file the PCT application and convention application as per section 135 of Parent Act. By these two routes, you can file your application in the foreign country also. Again, IP is called as an licensable right. It means you can license to anyone whom you want. For example, Pfizer has developed vaccines, but they have assigned the right to Serum Institute of Pune for more production. What is patent? Exclusive, monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing, or priority for commercial gain, not to keep it in file record. When you are disclosing clearly, then only you are getting the right as a territorial right, not worldwide. If you are not disclosing clearly, then you are getting objection from the government of India that your invention, your technology is not fully particularly serving to meet the requirement of section 10(4) of the Patent Act. Therefore, you write in detail in the application simply before getting the objection from the government of India. For example, you are using different shampoos to take your head bath. Somebody Vatika, Sunslick, Doe, Wow, many shampoos are there in the market. Why you are being pharma people? You are being a scientist in this people. You are being belongs to scientific community. Why you are using different shampoos? I am working on medicinal chemistry, so I am also developing improved herbal shampoo composition for treatment of dandruffs. I can get patent for that if I show improvement over the all the shampoo which are there in the market. Then definitely no one can stop you from getting the patent for that. But you have to disclose all the details from where I am getting the medicinal plants composition, what parts I am getting, place of that, whether I'm taking NBA permission for that or not, details of that, examples, efficacy data, clinical trials, all I'm supposed to give. Then only you're getting the right for that. B pharmacy fellow, M pharmacy people are doing project. Research fellows like PhD fellows are doing research. During your project or research, you should understand whether your research topic, whether your project topic is qualifying the definition of invention or simply you're going to the discoveries. So, discovery means finding or exploring something which already is the nature, and discovery as such no technical effect. For example, I am taking my BFARM project as an isolation of bacteria from effluents of Reddy's laboratories. I know that effluents having some microbes, but I am developing new process for isolation of microorganism by changing pH, temperature, media of that, and I'm isolated also. I can get patent for the process of isolation because it's new, but not for the microorganism because it's discovery. I know that effluents are having, so I'm just discover it. Therefore, discovery is not patentable. But genetically, if I'm modifying that microorganism by using genetic engineering technology or recombinant DNA technology, then definitely genetically modified microorganism I can get patent for that. Like oil eating bacteria is the example of that. So discovery has no technical effect, therefore you are not getting patent for that. But for the invention, you are getting the patent. So let us see what is invention. Invention means new product or process. ATM machine, new product. Herbal composition for the cancer, new product. Arthritic drug composition, product. Process of making composition, process of making beverages, beverages composition is a product. So useful to all. Something novel, non-obvious, and should not be in the public knowledge before the filing date. Even if you are publishing the paper, you check whether your research topic, whether your PhD topic is qualifying the definition of invention or not. Same way, you can check whether a paper published is in the international journal, national, or local. If not, then only you are going for the publication. To qualify the definition of patent, your subject matter should fulfill this criteria. Then no one can stop you from filing the patent. But granting of the patent is with respect to section 3 and 4 of the Patent Act. As section 3 relates to non-patentable links, like method of treatment, we are not giving patent. Plant as such, we are not giving patent. Method of agriculture, we are not giving patent. Please check section 3 and 4 as its awareness program. I cannot go in detail. Simple example I have taken pencil and sharpener. Pencil are known to us, but sharpener, earlier we used to use the blade but now you are using sharpener. Why? Somebody has brought that device that is called invention. In the school level, in the general knowledge, we also who has invented rabies vaccine, who has invented polio vaccine, who has invented many things like electrical bulb, aeroplane, even this telephone. We know. But can anyone tell me by that why this telephone was there? Even the British, when ruling our country, they used to speak in the foreign countries by using this telephone, even though we got the mobile phones in the public. What was necessary? Why we thought to give the mobile phones? Because this device is having some disadvantage. I cannot change this device from my cabin to my dean's cabin or my HOD sir's cabin or my principal's cabin because it is connected at a particular point. If phone come, you have to come and speak. Again, if I want to dial 10 times, I dial very hectic and time consuming. To solve that problem, to solve that problem, we got the mobile phone. In between, we got this telephone. I can dial easily 1, 2, 3, 4, but I cannot change from my cabin to my dean's cabin. To solve that problem, we got cordless phone we can take in the hall, kitchen, drawing room. After that, we got the mobile phone in India in the year 2000 or in and around that. Simple Nokia was there, silver color, and more than 5,000 rupees was the price. And only incoming, outgoing were there. Now we are having video calling facility. Google Meet, Zoom Meet, WebEx. What is this? Improvement of technology from ageable to mobile phone. So Nokia got patent, Apple got, Samsung got. So from this example, I want to make you understand that don't think getting patent is difficult. Even you are improving your process, product, composition, you can get patent for that or any devices also. For example, I take for my example. I am having a process of production of beverages from the grapes, earlier process, wherein I am getting very less yield for 1 quintal of my grapes, very less yield, like 10 to 12 liters of raw alcohol by this my process, my known process. As I am a chemist or pharmacist, again I'm an chemical engineer, so I'm developing new improved fermenter and process for production of beverages from the same grapes, wherein I'm improving my process. I'm getting more than 80% more yield than earlier process, so I can get patent for improved process of production of beverages from grapes because I'm showing 80% more yield, not 15 all, more than that. Then definitely you can get patent for improved process of production of beverages from so and so, because you are showing lot of improvement. X-ray machine got patent, and doctors say that you are having some infection, but we got CT scan machine. Doctor says you are having 5 score of infection, 6, 7. What is this? Improvement of technology from X-ray to CT scan machine. So we are getting patent for the improvement also. Please keep in mind. See, Bluetooth is an example of invention. Front-facing camera is not there, only mobile incoming, outgoing. Now we are having front-facing camera. EVS got patent for that. Earlier we are registering attendance in the register. Now you are having biometric scanner. Again, invention or technology. See, simple inventions. Vaccines, nanocar. We know who has invented rabies vaccination. Louis Pasteur. Penicillin allergen. So, first time who brings the technology, they got the patent. They are called as an inventor. So, these are the examples of patent, like drones, smart car, the example. So, patent is given for product, process, compositions, medicines, drug, devices if they are new, novel, inventive, and capable of industrial application, and they should not attract section 3 and 4 of the Patent Act. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, ornament, or composition. You can check this iron box in your home. What is iron box? You can check your mobile, watch, earrings, fingers. So all the designs are different. You can check your comb. My comb is of this design. So anything which looks beautiful, that's a design. Flash design, brush design, car design, even handle design. Mere functional feature of the article is not considered design. Only take how it looks, that's a design. Term is 10 years. It can be renewed every 10 years, subject to usage and total. Sorry. Term is 10 years. It can be renewed only for 5 years. Total 15 years term for the designs. Means once you are creating a design, up to 15 years you can get the royalty from whom you are selling or giving license to use your designs. Beautiful cup set, new design. Sanitizing machine, it was not there before. During Corona, we saw this. See, new designs. Ampoules, ampoules, ampoules. Syringe, syringe, syringe. Capsule, capsules. All the designs different. This thermometer we saw during the Corona. So anything, if you are developing new, go for the design registration. Textile design, jewelry design. See, watch of Titan and Timex, my simple watch. So your watch, you can check all the designs. If it is new, you can go for the registration in the Government of India. Daily consumer products, office log, wallet, water bottles of Coca-Cola bottle. You can check Maja, Sprite, Coca-Cola. All are different bottles, but you never thought. Since your childhood, you are drinking that Coca-Cola Maja, but it never comes to your mind why this bottle is like that. Kolhapuri chappal, Adidas shoes, Piba shoes, fan, all the designs are different. See, surface pattern of the bottle is different. You know, sharpener, but dual in nature. Pencil, peacock facing or parrot facing, new design. See, new designs. This design was developed by one of the student of National Institute of Design, Ahmedabad. You are also doing project, but you want to get only degree, therefore you are not doing any inventive work. You might have going to the libraries, copying the senior thesis, just change the data. If I am selecting phytochemical studies of two medicinal plants, which are Rigacia and Tinctoria, so you might have changing the same name of the medicinal plants, you are carrying out same parameters. So it's not an innovative work. Just you are duplicating the work. You should do. So this fellow has developed new design for the people who are working in the construction company. If they are carrying out stones, bricks, sand, cement directly in the hand, so on the head, so they are having neurological disorder, back pain, disc pain. To solve that problem, they have brought the design, and it is not on the head, it's above the head. There is a problem, somebody is solving this. Again, it's a new design. Let us see another kind of intellectual property called semiconductor integrated circuit layout design. It should be original, new, then you can register in the Government of India. Term is 10 years. Earlier, we used to use China chips, Taiwan chips in our hardwares. You know what is trademark or brand name? Reddy's Laboratory, Biocon of Bangalore, Serum Institute of Pune, Glenmark. What is this name of the company? We advertise that company. It's name of the company. Therefore, you have to keep the name of the company, register that, because it's protect any product of that company to the innocent. R with N circle is a registered trademark. TM means you have applied for the mark yet to get permission from the Government of India. Duration is 10 years. It can be renewed every 10 years, which is like Tata Bata, how long they're in the market. So ICICI, FedEx, Amazon, all the name of different got trademark. There are different trademarks, collective marks, certification marks, taglines, slogans like Google, Adidas, Dil Mange More, Bureau of Indian Standards. All these are different kind of trademarks. Let us see another kind of intellectual property called geographical indication. Place name used to identify source of origin, quality, reputation, or other characteristics like Darjeeling tea, Kanchipuram silk sari, Tirupati laddu, Kolhapuri chappal, Agra petha, Nagpur oranges. The term is 10 years. It can be renewed every 10 years, subject to the uses. See different examples. Katputli of Rajasthan, Bangpin from Madhya Pradesh, Bengali Patchitra, Bidriware from Bidar, Karnataka, Chirali paintings, Orly paintings, Magai Pan, Devanali Pamilu, Apimidi Bango, Kashmiri Saffron, Sahili Chabiyar, Cork oranges. Let us see another kind of intellectual property called copyright. Copyright is a bundle of right. It restricts unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and software. The term is life of the author plus 60 years. Therefore, you are getting royalty for that. Many singers are no more, but still they are getting royalty for their songs. Many authors written the book. Now students are referring, but still they are getting the royalty for that because of this. The if you are writing book, novel, story, autobiography, or any literary works, you are getting protection under Section 2 of the Act. If you are doing artistic work under Section 2C of the Act. Drama if you are writing 2H. Musical works 2P. Sound recordings 2XX. Cinematography films 2F. So each kind of work is getting protected in the copyright. Therefore, we can bundle of rights. You might have heard Sham Sundaram movie in Telugu. They have discussed about copyright. Three Idiot movie discuss about the patents. So everywhere we are knowing about the intellectual property rights. If you are doing something new, please get it protection in the government of India so that no one can copy your technology, nor any literary works, nor musical works, nor sound recordings, nor cinematographies or artistic work. The term for protection for the literary, dramatic, musical, artistic life of the author full plus 60 years. For cinematography films, since the date of publication, 60 years from the date of publication. When your film publishes, from that 60 years, you are getting royalty for your movies. Now, what is the fees for other filing? Literary, dramatic, artistic, musical, 500 per work. Artistic, 2000 per work. Sound recordings, 2000. Cinematography films, 5000 per work. You are supposed to pay the fees. Let us see another kind of intellectual property called trade secrets. Some invention, data, information cannot get protected by means of IPR. Such information has to be kept secret. It's called trade secret. Like if we are having any idea, survey method, manufacturing process, experimental results, chemical formula, financial strategy, client database. If you're having all those things, if you want to publish, you can, or if you want to keep secret, it is left to you. Like Coca-Cola formula, we don't know. Cape's recipe, we don't know. Maza recipe, we don't know because they are maintaining as a trade secret. Even you can get protection for the new plant varieties, seed varieties, food grain varieties also, but not under the Patent Design Trademark Act. It's under the Protection of Plant Varieties and Farmers' Right Act on 2. If the varieties are novel, distinctive, uniformity, and stability, they can go for the registry in the government of India. Like who can, breeders can file, farmers can, university can, other university can also file for the new varieties. Term is 15 years for annual crops, 18 years for trees and vines. This about the protection of plant varieties. I have taken simple example to make you understand. The symbol Apple, you know, they got trademark for that. Display after putting the laptop keyboard, we are getting some output. That's some technology they got patent for that. Overall body of this design they got. User manual they got copyright. Inside this circuit they got so that no other company can copy the design, trademark, logo, or content of that because he has protected all. So if you want to quote 1 lakh price for the laptop, you are supposed to take. Otherwise, we can go to Dell, Samsung, or any other laptop because they have got protection. So that's again power of intellectual property. They cannot. I'll quote another example. Formulation of Coke. What is inside we don't know. That is called trade secret. Coca-Cola in this fashion is a trademark. Bottle design small, increase size small, again in degree design. So again, design of the bottle. Patent they have obtained in respect of bottling equipment from which I'm making the bottle. That instrument, if it is new technical, then they might have got patent for that. Copyright in respect of text, database, artistic work, appearance, website is all they got. Therefore, they cannot copy each other technology, nor design, nor name like Mazar Sprite. You can check different mobiles. Nokia, Samsung, Reliance, they also got patent, design, trademark. Therefore, they are in the market. If you want to go for Nokia, you can go Samsung, Motorola, or Apple, or OnePlus, whatever you want. That's power of intellectual property rights. You learned all about the intellectual property basics, how to convert your research into patent application or project into patent application. Now, let us see what are the career opportunity for the students here. If you want to come as an exam or patent and design, you should have qualification in MS chemistry, biotech, microbiology, physics, or any branch. Be depend upon the advertisement and vacancy. If you want to come as an exam trademark, GI, copyright, you should have law background. Again, if you want to work in trademark agent, then any arts background fellows can write the exam. If they qualify, they can practice also. There are many IPR cell, IPR policies are there. You are working with them. If you want to work again, you can also, if qualify the agent exam, you can go for that. NGOs, you can work. IPR firms also you can work. There are many IPR firms who are hiring the patent agents, those who are qualified the patent agent examination of the Government of India. As I told you, you may be scientist, professor, faculty, but you are not inventor because you are not filed any patent on your name. So you follow simple approach. While carrying out research or a project, identify some problem, solve that problem, then you can apply for the patent. For example, herbal composition for treatment of cancer. It's not in the public domain. You can file. Or herbal composition for treatment of psoriasis, improved shampoo composition for swine. So whatever you are able to show good results than earlier one, then definitely you can go for the patent. Now, again, you learned how to become an inventor. Let us see how to file the patent application in India. Who is eligible to file the patent application in the Government of India? Any person, startup, MSME, individual, alone, company, anyone can file the patent application or combine with the others. There is no age bar limit nor educational limit to file the patent application. Even uneducated fellow can also file. How to file? Directly can go to your jurisdiction as you are from South Chennai jurisdiction, or since July 2027 we have given online facility, you can file online also. Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu. Union Territories of Pondicherry, Lakshita. You can go for that. If you want to file online, offline, the option is with you. What are the documents required for filing the patent application? Covering letter, indicating the list of document, that is form 1, form 2, so whatever may be, you are supposed to take. Form 2 for application detail filing. Form 3 foreign filing details. Form 5 to add your friend's name. Form 18 request for examination. Until you file, you never examine your application. Fees for filing the patent application is given on the website, even though if you want to know, 1,600 for natural person, 800 for others, up to 30 pages online fees. Filing fee is the product of basic filing fee as is given here. If it is exceeds more than 30 pages, 160 per page and 800 per page for the company. If you are exceeding more than 10 claims, 320 for individual, 1,006 for others to pay the royalty, or 80% fee concession for all the teaching institute who are there. So you are from teaching institutes, you are having 80% fee concession to file the patent application. If you want to file hard copy, 10% more you are supposed to pay the fees which I have mentioned here, 1,600, 10% more than that. Request for examination 4,000 per natural person, 20,000 for others. Others means companies. Form 9 is an early publish request. If you want to publish, you can. There is no compulsory for that. Otherwise, 18-month publication is also okay for that. Now, if you want to get patent within 1 year, you can do expert examination as per 24B. Form 18 is must. While filing the PhD application, if India is an ISA or IPA, then you can. Or applicant is startup, then you can. Or as per 2019 rule, one of the applicant, if you group in ladies, then you can file the patent application. This is our website. If you want to know more about the patents, click clear, designs, trademark, GI, and copyright. If you want to file online, comprehensive e-filing. Click here, then patent, design, trademark will come. Whichever you want to appear, you can file with that. Public search. You can check herbal composition containing caustic for treatment of kwashiorkor marasmus disease. Herbal composition as in chocolate for nutritious malnutrition children's, or food composition for treatment of so and so, medicinal composition for treatment of so and so. You can put whatever title you want and you can file the application. If you want to search whether new or not, then public search, go there, put your content name, then you can search. If it is new, then you are not getting any document. If you are not new, then you will get the some citation document we call prior art search. So you can go to Google, public search or Google patent, EVSO patent, EPO patent, WIPO patent. All these are freely available database. You can search and get your work done or know about before doing the work. Again, if you want to file and print application, then you can go with the website, online filing, or offline, it is left to you. If you want to file copyright, go to the copyright office, create your ID password, fill the form, then upload the document. The waiting period is 30 days. Then if you are accepting, the letter will come to you. Otherwise, you get the objection. You are supposed to reply for that. It's about the copyright. So anything, if you want to know, please visit to our office or on the website. Everything is available. So let you learned about the patent design trademark filing. Now, if you want to file and design application, then who is eligible to file and how we can file? Any person, startup, MSME, other than ₹1,000 and companies 4,000. You have to write all about the applicant details with the address, two set of presentation you are supposed to prepare, power of attorney through lawyer if you are going, prior document if you are having, assignment, and form 20 if your applicant is SMEs. There are 32 classes of the design. Locarno class. For example, if you are filing then suitcase or briefcase, class 3 travel goods. If you are filing the musical instrument, class 17. If you are filing pharmaceutical and cosmetic products, class 28. Machines, class 31. So which class you are yours to classify your design, then you can file for the design application. You have to write how your design is new. This teapot, name of the college PVSC Hyderabad, Women's Pharmacy College, total number of students, 8, one of it. Front view, back view, top view, side view, perspective, all the views you have to take and each seat, one of two, one of three, like you have to submit all that is personally. So this is about the design filing. This is the bad quality. What is the role of patent system? Encouragement or improvement of technology? Providing reward as an exclusive right for disclosure, making profit or earning royalty through putting the initiative practice. Once you are getting the patent, you are supposed to pay the renewal fee. If not paid, then it will be seized. Then anyone can use your technology. So always keep abreast with the technology. What to do? You came to know about the different kind of intellectual property, how to create, how to protect, and how to file also. So please don't wait. Share the benefit of patent system in school, colleges, university, and the public. Utilize the resource through organized R&D activities. Capture the market globally or judicially. Earn the profit through protected market only. So, as Sony, Samsung, both are the TVs. They are protected. They are in the market. Same way, if anything you are bringing, please earn the profit. Don't keep as a file record. With this, I put a full stop to my presentation. Thank you. Any questions we'll take now. Any question, please ask one by one.
So, thank you, sir. Thank you so much for your valuable insights and engaging presentation. There are some questions, sir, from our students.
One by one, you can read for me.
Yes, sir. So one of the student has asked, like, how does Government of India protect traditional knowledge of medicine from pharmaceutical company?
Very good. See, at present, uh, the pharmacy company which are filing for the patent with the herbal compositions will search that composition which plants they have used in the traditional digital library. In that, if you are coming to know this plant is particularly used, then object the objection as it's in traditional knowledge. Then they have to explain, applicant to explain it's not a traditional knowledge. If he is able to satisfy, then only we are granting the patent. Otherwise, traditional knowledge is not given patent under section 3P of the Patent Act. Please read with that. It relates to traditional knowledge is not patentable. If you are using medicinal plants, you have to disclose which area you are disclosing, and you have to take the NBA permission for that also. So traditional knowledge as such is not given patent for the pharma companies under Section 3P of the Patent Act.
Okay, sir. Okay, understood, sir. So, second question is, who can initiate infringement action in India?
Anyone can. For example, you are developing some drug and somebody is using that. So if he is infringing your patent, then you can file a suit against him in the court that he is infringing my patent. In India, you can, who is having the authority or patent, he can also file the suit for infringement.
Okay, sir. Okay. So, the third question is, can I register patents with Indian customs?
What exactly Indian custom is, what they are. You can register the
Yes, sir.
patent for any technology, product, process, composition, machine, devices. But what customs are? If you are able to tell me what customs, then I can define it is patentable or not.
Okay, so here the question, there is no clarity in the what
Yeah,
customs
please
here.
ask the student who has written that. Please write more clear about the example of the tradition.
Okay, sir. Okay, okay. Sir, what facilities are available for startup in case of IPR?
80% fee concession for filing the patent application, expert examination, and many government institute are there. They are helping to write their application, and they are paying our office will pay the fees for the agents who are writing your application. You can go to the website and clearly check who are the agents on the record to file your application for the startup and MSMEs.
Okay, sir.
Any other
So the
question in
last
chat box?
question is, okay, sir.
Can I?
Can I publish my work before patenting?
Yes, you can publish your work, but from the date of publication, within 1 year, you are supposed to file your patent application. It's your own work, but within 1 year from the date of publication of your work, you have to file the patent application, not beyond that date.
So
But
after, like, if the publication is done long before, so can we go for a patent? No.
no, no.
So till 1 year of publication only it can be.
Always try to do first only. But what happened in teaching field, sometimes you have to go for some workshop, sometimes you have to go for a paper presentation, then you have to put your paper, then knowingly unknowingly you are disclosing to that. On the same date from the 1 year you can file, but not beyond that.
Okay, sir. So, like, is the can the total work that is published can be patented, or a part of it?
Whatever you are publishing within 1 year from that work.
Okay, sir.
Okay.
Okay, sir. Okay. Thank you so much, sir. All the questions are completed. On behalf of everyone here, I would like to express my heartfelt thanks and truly appreciate your time and expertise in patents. Thank you so much,
Ma'am,
sir.
I am giving one link on your WhatsApp.
At
Please
the end of the
circulate to all.
screen here.
I am giving one link to you. Please circulate
Okay,
to all.
sir. Okay, okay. Okay, okay, sir. Sure, sure.
So I'm putting on
Sure.
your WhatsApp.
Yes, sir. Okay, sir.
Just a minute. Huh? Uh, here, can I put chart? Is there here chart? I can do chart here. No, I cannot put in. Okay, I can put here. So please see the feedback link. Fill this link for certificate.
Yes, sir.